Join me in the pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Greet your neighbors.
Hey, President.
Our invitation today will begin by Don.
Let us express our gratitude for the opportunity to serve as Rotarians and to fulfill Rotary's mission, for the gifts that we have that enable us to make a difference in the lives of those we serve, for the chance to do something special and meaningful with our lives, to help embrace and challenge the responsibility we have as leaders. Guide us to lead with integrity and common sense. Give us the character to make the right decisions and help us to always be welcoming, inclusive, and open because of our vision and our mission to serve. Amen.
Thank you, Don. Just a couple quick announcements today. One is over here on the side table in the front, we laid out all the various proclamations that we received at the 100th anniversary dinner a week and a half or so ago. So if you're interested, those are up front. So the weekend, I always have to give my football update for the weekend. So the Buckeyes actually didn't play, but moved up in the polls. So you have to like that. And the Browns, of course, reminded us that they're still the Browns. So. I wanted to also let you all know that we do have our nominating committee formed. So the members of that are Bob Gorman, Lynn Mumal, Kim Sayers, Peggy Schmitz, and Justin Starlin. And that group was busy working this morning at 7 o'clock. Well, maybe it was about 10 after 7 when Justin showed up. They were busy this morning working on our slate of officers for the coming year. So more information to come on that group. Also, a quick announcement on the Alabama Wheat Classic. Becky Foster and Steve Glick are helping organize that this year. They couldn't make it to today's meeting, but I wanted to at least let you know the dates. So the clinic that will be for the students will be November 14th from 2 to 4 p.m. And the tournament dates for the games will be Friday, Saturday, November 19th and 20th. So we're getting back to pretty much normalized, I think, with this event, with a few exceptions. Some of the food pickups from the schools changed a little bit last year. I know Wooster City is delivering all of their food directly to people. And Triway sets it out for us to pick up over a 5-day period, and that's going to stay the same this year as it was last year. So Becky will be reaching out to Rotarians for volunteers to help with the food drive and those pickups in the coming days and weeks. Also, I know Becky's not here, but I wanted to recognize one of our own Rotarians, Becky Foster, who got the Athena Award for 2020. So it's always good to see. It's a well-deserved award for Becky, and appreciate that she was able to get that award. So I wish she could have been here when I had this up. But if you see Becky, make sure you extend your well wishes to her. And your history for today is that on October 18th, 1963, the first cat was launched into space. So Felicette, she made it back. It was a 13-minute flight, and she made it back to Earth. Unfortunately, there were 14 cats trained for the mission, and they did lose one on the launch pad. There was a malfunction on the launch pad, so we did lose one of the 14. police have made it back. All right, at this point, I will turn it over to Secretary Lynn and the Secretary's report.
First, we'd like to welcome our newest member, have Dr. Heather Howley come up, please. Dr. Howley is the Director of Regional Campuses for the University of Akron. She's a resident of Orville, so we're very pleased that she chose Wooster Rotary. Welcome.
Thank you.
And one thing we would like to say, they probably can't hear us, maybe they can. The cooks, we're down to 3 of 7 cooks, and they still produce lunch, so thanks to them. Amy Welty has the traveling microphone, and we'll start with Treasurer Greg Long.
My guest today is Sue Smale, Wayne County Commissioner.
Lyson also has a guest. Greg Barbu has a guest. Thank you. Sorry, Greg.
My guest today is Dick Shantz, president of Shantz Organ Company and founder of the Shantz Makerspace, which is now down at the Wayne Center for the Arts.
Welcome. And an upcoming speaker, correct?
Correct.
You're good. Welcome.
Thank you, Lynn. Welcome, Vic and Sue. Appreciate having you with us today, and I hope you've enjoyed today's program and the fellowship of Wooster Rotary. At this point, I'm going to hand it over to Dee Vida, who will be introducing our speaker today.
Folks, Ohio Supreme Court Justice Sharon Kennedy began her career in the justice system as an officer for the City of Hamilton Police Department. Following her time on the police force, Justice Kennedy obtained her law degree from the University of Cincinnati College of Law and entered the legal field as a solo practitioner. During her time in private practice, she also served as part-time magistrate in the Butler County Area Courts, as well as special counsel for former Ohio Attorney General Betty Montgomery. She was elected to the Butler County Court of Common Pleas Domestic Relations Division in 1999, where she also served as the administrative judge from 2005 until her election to the Supreme Court in 2012. Justice Kennedy has received multiple awards, including the AMVETS 2018 Past Department Commander's Civil Servant of the Year Award and the National Society of the Sons of the American Revolution Silver Good Citizenship Medal in May 2018. She's also the recipient of Leadership Ohio's 2016 Community Leadership Award and the University of Cincinnati College of Law's 2014 Nicholas Longworth III Alumni Achievement Award. Additionally, Justice Kennedy was featured in Trends in the Judiciary, Interviews with Judges Across the Globe, which was published in 2015. She was named one of 13 professional women to watch by the Cincinnati Enquirer in 2013 and was awarded Judge of the Year in 2006. Justice Kennedy serves as the 154th Justice of the Supreme Court of Ohio and is the 9th female justice to serve on the court. The last day of her current term is December 31st, 2026. Ladies and gentlemen, Sharon Kennedy.
Thank you for that wonderful introduction, and thank you for the opportunity to be back at Wooster Rotary. I was here 2 years ago, and we spoke about the First Amendment, 45 of the most important words ever written. And I remember the question I was asked. Someone brought their young son who was in law school, who asked me the question of whether or not the president was prohibiting someone's free speech about the interaction with the NFL. It's questions like that that keep me coming back to civic organizations that make this a lot of fun for me as well. In looking at where we are, I actually thought you might want to look behind the curtain at the Supreme Court of Ohio. What is it that we really do? How we go about our work? Where do we get our powers? How do we write those decisions? If we begin with where do we get our power, it's from the Ohio Constitution. And it comes by way of the US Constitution. It's little known, but there is an article, Article 4 of the United States Constitution, that says all states shall ensure a constitutional form of government. They actually call it a Republican government. They don't really mean Republican like party, they mean Republican like the Republic that we just pledged to. When you take a look at that and then you cross-section it with the Ohio Constitution, we have a little bit of the reverse. Article 1 of the Ohio Constitution is your Bill of Rights. Written in 1802, has been modified over time. The largest swath of our Constitution came into existence in 1851. There have been many amendments to it. We are unlike other states where you have the ability to put on the ballot an opportunity to grow your Constitution. And we have. Our Constitution now spans 100 pages. Depending on what you think your Constitution should hold, to me, it goes beyond the borders of what I think a constitutional document is in shaping a form of government. We now set minimum wage by the Ohio Constitution and many of those other amendments that you see that are outside the structure of government. But when you look at our powers, the Bill of Rights being the First Amendment, your voice, the legislative voice, is Second Amendment. The executive branch is the third. We're Article 4. And all of my powers stem from that one article. It talks about all the courts broadly, because there are different levels of courts. And it gives the power to the General Assembly to actually establish courts as necessary in time, but also to assign jurisdiction. So when you look at the Supreme Court of Ohio and what we do, some of it is commanded by the Constitution itself. The Constitution states that we have original jurisdiction over certain types of cases. They are the great writs: habeas corpus, mandamus, quo warranto, precedendo, prohibition. We have a constitutional duty to review as necessary until full resolution of a case. And we are exclusively in charge of admission and discipline to the practice of law. We have appellate jurisdiction. Some of that comes by way of the Ohio Constitution. Many of you may not remember, but in 1994, a majority of Ohioans enacted a provision that allows death penalty cases to go right from the trial court to the Ohio Supreme Court, stripping out the intermediate appellate court. But the Ohio Constitution also gives me authority to pick and choose the cases I want. If you look at your court structure as a pyramid, the base would be your municipal courts and county courts. They will hear about 2.3 million cases a year. Your next step up is the courts of common pleas. They're going to hear about 600,000 cases a year. The next step up is the intermediate appellate courts. And if you're appealing to them, they have to take every case. But in the Ohio Constitution, you gave us the power to decide. 4 justices of the 7 must believe it meets this commandment of the Ohio Constitution. It's a matter of great general or public importance. In other words, it touches all of us. If I crash my car into D as we're leaving the parking lot today, and he ends up suing me, and he doesn't like the decision because he didn't win, and he takes it up to the appellate court and he loses there, he can appeal it to the Ohio Supreme Court. But if it's just about the issue between us, it's probably not going to get in. But what if the issue is something about his insurance policy? That is something that's in all of our policies. More likely than not, that case is going to get in because it's no longer about us. It's about all of us. So when you're looking as a reader at those things, I'm looking for that case that touches every single one of your lives or has the potential to. And then we have these questions that were asked. The Ohio Constitution says if the appellate courts are in disagreement, and this happens, the 8th District Court of Appeals in Cuyahoga decides an area of law, and they say the law is X. And then the 1st District Court of Appeals down in Hamilton County says the law is Y. Who settles that disagreement? The Ohio Supreme Court. But we also take in cases from federal courts as well. And how would that happen? Sue's a federal judge, and she has an Ohio case with Ohio litigants. The question of law is one of Ohio law. The Supreme Court of Ohio has never addressed it, has never applied it. So as a federal judge, she would write a question to the Supreme Court and say, I am getting ready to hear this case, and we want this answered by your court. What would the Supreme Court of Ohio say the answer is? We choose to take it in or we don't. If we do, we're going to answer the question, send the answer back to her, and she's going to go on with her trial and answer that question. So that's our power and where it comes from. But when you start looking at that second tier of how that case gets in, I think you should know that we're reading about 1,200 of those. Compare that to the United States Supreme Court. It was just recently in an article that 10,000 cases are filed with the court asking to get in. They take 80. Our court, we read 1,200. We're going to write opinions on about 300 cases a year, both with a majority offer justice or a per curiam opinion. And although those numbers look differently, also how that opinion happens is different. Unlike the United States Supreme Court, where you do not get to look at what they do, you can see what we do every time we take the bench. On October 26th, we're going to be up at the University of Akron. We call it off-site court, and they will bring in high schools from the surrounding areas so they can come in and the students can watch oral arguments happen in real time. You can watch them as well from the comfort of your home or your desk. You literally go to the Ohio Supreme Court website, and at 9 o'clock, the screen will flip, and the Ohio News Network channel will run the oral arguments live. They're all archived, so you can go back, and if you see a case and how it was decided, you can actually go back to the archive to the date that it was argued and see the arguments in real time. The US Supreme Court only allows you to hear an audio. One of the things that was funny after COVID, and they went to in Zoom meetings, is all of a sudden in one of the first arguments, you hear a toilet flushing. Well, obviously that was in someone's chambers that was going on. And all of a sudden it was just like the world stood still for a moment. And that's still one of the most played clips that are out there about the US Supreme Court. So as you're looking at that case, you see both sides come and argue. Think about what goes into that. Two sides, lawyers, hours, 7 justices who have all read the material and probably one of their staff attorneys. Hundreds of hours are now into this case as it's being argued. As you see all 4 cases happen, it is after the close of that, we'll go upstairs to the 9th floor and we will sit around a table. Right now we're still Zooming this part. And we actually discuss these cases first. Within a matter of hours of hearing it, we have already taken a vote and how we believe the case should be decided. What is the rule of law that should be written? What does that mean to the lower court's opinion? Is it reversed, affirmed, remanded? Does it go back to the trial court or the appellate court, or do we resolve the whole case here? All of those decisions are made within hours of oral argument. It's an open conversation. It starts in reverse seniority with the most seniors of justice speaking first and going around the table until the newest justice has the final say. Then there is a great general discussion over the law. You have the ability to debate your colleague about why they think the law is X, or what was in the record that causes them to believe Y. As that conversation then unfolds, Positions will change around the table. There is a final vote that is then taken in reverse order, with the youngest justice in time casting the vote first. In addition to those cases, we vote on all those other cases. Some of it's done electronically now. We call it the batch vote, where all of these series of cases are read in chambers, and I electronically vote on all of those cases. Some of them are the great writs are still voted on and voted off at conference because they're going to be written. There's going to be an opinion on some of them if they're not dismissed by law. So as you're looking at that complexity of what you're voting on, there's a lot of moving parts. Once we've wrapped up the discussion of oral arguments first, we assign a majority author. It is not like the United States Supreme Court. In the federal system, Chief Justice Roberts, if he is in the majority, he gets to personally decide who writes that case. That's why he writes so many. If he is not in the majority, then the justice most senior in service gets to choose the author. We don't do that. It's a pool hall game, I'm told. It's a leather bottle, and there are 7 pills in that bottle. And if you are in the majority, I actually drop your pill number into the bottle, shake it up, and roll one out. You don't get a case just because you're so passionate about this area of law or you really want to write about it. It's totally random. And then you take a number 2 lead pencil and a grid chart and you fill that case number under that person's name. And that's how we keep track of who received what. And to make sure that it's balanced. Is it possible that I get 2 cases assigned? Sure. If I was the last one open on that block and that closes that line out, I could get the next one on the new line. But the system is really designed to make sure that we're receiving an even number of majority opinions. But why would those numbers come out differently? Well, let's say these 4 ladies were the majority. One of them has now written an opinion, and it comes to these 3 who were the dissenters. And the dissenters, one of them picks up the pen and they write a different opinion and say why they believe the majority is wrong. That comes to the table. The world never sees it. All of a sudden, she is so persuasive in her writing about what the law is, it causes 2 of them to leave the majority and join this new opinion. This dissenter now becomes the majority author. We call it flipping a case. She is now going to write the new majority that will come back to the table, and probably the original majority author is going to remain exactly where they are, and that becomes the dissent. I want you to think in terms of moral courage. And I say it like that because that's really what it's about. I spent 14 years in the trial court. I was a decision maker of 1. I tried every final contested hearing myself because I didn't want families to have to go through a secondary step of litigation. If they wanted to appeal the decision, then they would go right to the appellate court. So I did not allow magistrates to hear my final contested cases. But think about it, I was the decision maker of 1. It was what I thought. But now at the Supreme Court, you have to take very good notes to understand how that majority is shaped. So you have to write it exactly how these 4 believe the law is. Not go too far, not do enough, exactly what those 4 is to keep your majority together. But the moral courage comes when you stand alone and you say, I disagree. I was a baby justice back then. I was in my first term, and I was in my first year. And I'm sitting around this room thinking, these are really smart people. There are many years of judicial service at this table. An even greater number of years when you start looking at staff attorneys who have also looked at this. And I just could not buy what the majority was writing. To me, as I read the words of the statute, it seemed so clear to me. I could not understand how they ever could reach that result. based on the language of the statute. I fretted about that case as much as I fretted about my cases in the trial court. Sleepless nights, pacing the floor. Was I making the right decision? Because what I did in the trial court, I impacted everyone's life in that moment, in a heartbeat. But here I'm impacting the law for all of Ohio. As I thought about it in those nights, sleepless, it's how could I see this so differently when everybody else saw it completely the other way? It would have been easy to cave. There's a study out there that says the more of groupthink, the more you will not stand firm in your core belief. That study works like this. All 6 of these people are sitting in this room. There's only one person that's not in on the game. He comes in as the observer and he holds up cards. The color on the card is clearly red, but the 5 Confederates all say that it's orange. More likely than not, the one that does not know that there's a game afoot will cave and say it's orange, even though they are not colorblind and it is clearly red. That kind of groupthink could happen at the Supreme Court if you allowed it. But having the moral courage of my conviction, I wrote that dissent. To the rest of the world, it was nothing. It ended up on the front page of the newspaper when my colleague, Justice Pfeiffer, came walking down the hallway. Our office doors were next to one another. And as we're leaving conference and I'm walking down the hallway with him, he said, "So, that little know-nothing dissent you wrote, it's all over the front page of the paper." And I looked up and I said, "Really?" And he busted out laughing and he says, "Yes, don't you read the newspapers?" I said, "I don't have time for that right now." In that moment of having that moral conviction is really about showing all of you what you are as a thinker. You see, on that continuum of judicial philosophy, what that shows you right then and there is, where am I in the philosophy? Only with what you have declared the law to be. If you think about the founders and Alexander Hamilton, who wrote the most famous, most quoted Federalist paper of them all, Federalist Paper 78, what he says to us as judges and justices is we have an obligation to use reason and judgment, not to decide a case based on what we personally feel the law should be, but in what the text is as written and when it was written. For he said, "There is no liberty if the power of judging be not separated from the legislative and executive powers. The complete independence of the courts of justice is clearly essential in a limited constitution. The courts have the duty to declare all acts contrary to the manifest tenor of the Constitution void. Without this, all reservations of particular rights or privileges would amount to nothing." I would think that as you look behind the curtain of the Supreme Court and how our powers are shaped under your Constitution and how we go about exercising that power, you would be proud. That you would know that every case that comes before us is fully litigated and vetted, debated respectfully by my colleagues and I. And that at the end of the day, in arguing about the law and focusing on it, that we have the moral courage of conviction to stand against groupthink and tell people what we truly think the law says and why. I was recently asked in 2020 why I write dissents. And I looked at the questioner and I said, if I didn't write a dissent, how would you ever know what I thought? Think about the lack of courage it would be to have a 25-page majority of opinion, and at the end of it, I just say, I dissent without an opinion. What does that mean to you? And how would you ever know what's really going on behind the curtain if we're not said what is? You are the leaders of your community. I want to thank you for being Rotarians. I said it the last time I was here, and I still mean it. Organizations like this, they are the last bastion of hope for communities and for those who struggle in them. You have been the beacon of hope around the globe, fighting polio and making sure that those who water, a simple glass of water, is the difference between life and death. And making sure that those villages across the globe are actually receiving life through drinking water. Without people like you committed to your communities, we would not have strong communities. We certainly would not have a strong state. We would certainly be in worse shape than we are today. I want to thank you for choosing to be Rotarians and to care enough about your fellow man to do something about their life circumstances, even when it doesn't impact yours. May God bless all of you, and thank you for the opportunity to be here.
So we have time for questions, and Lynn has the traveling microphone.
There's a gentleman over there. Thank you, sir. Usually when one starts, the others will follow, because we had spirited debate the last time I was here.
I'm not sure how spirited this will be, Justice, but thank you for coming. It seems to be in this time of dysfunctional government branches and widely varied public opinions that people are deferring to the courts to decide policy, which in my mind should really be the legislators' function. Do you find that? And if so, what's the court's solution to that?
I thank you for the question, and I would agree with you. The courts are not the place to decide policy. And why is that? Number one, the Constitution says it's not my place, as Alexander Hamilton wrote in Federalist 78, defining what judicial power really meant. But think about why you don't want me to be your policymaker. There's only 7 of us. So I'll go back to my table of ladies, 7 justices. What ends up happening in that moment is 4 people decide a case. They're not going to take testimony. They're not going to hear opponents, proponents. They're not going to do massive amounts of studies of what the benefit, cause, and effect. They're simply going to decide the law. And if they are shaping policy, then 11.4 million citizens in Ohio, the law is coming from 4 thinkers alone in isolation. That's why judges have limited power, only to interpret the law as it's written. The policymakers are the ones that need the moral courage and character at our time to have the debates and come to a resolution, not to simply shelf it because it's too difficult. Nothing is more pointed on that fact than the DeRolf case. It is the #1 case I am asked about of all time since beginning to run for the justice in 2011. There are 4 or 5 DeRolf cases, maybe even 6, and it was about school funding. And in every audience where I was asked about it, it was your question. Why don't you just tell them what is constitutional and why don't you just shape school funding? It's not my job. And you wouldn't want it to be, because you would only have 4 people perhaps making the decision of what school funding should look like for the state. And that is the tail wagging the dog. In our great republic, we are a republic. They could have given you a monarchy, a dictatorship, a pure democracy, or populist rule reigns. They didn't do that. They gave you a republic where the voice of the people controls government, even if it doesn't feel like it, in Washington and here in Columbus. It is your voice, and we have the same voice. In November, I have the ability to go home and vote. Like you, I also have the ability to pick up the phone and tell my representative or state senator he should or she should vote for this law, but not that law. But I do not have a third voice when I put on my robe and declare the law so, to make it up as I go. For if we do that, we will surely lose the republic. For your voice will no longer matter. Policy shaping does not belong in my branch. We would be blind, leading the blind.
I have a question, just out of curiosity. You talk about your staff. What is a typical staff makeup and what are their roles?
So each of the associate justices have 3 staff attorneys and an executive assistant. We each use them a little differently. The chief has a 3rd staff attorney or a 4th staff attorney because they do more of the behind the scenes administrative work that comes to the docket. So the chief has the power to set the docket. Some of them use them to read all the batch cases, all those things we vote on electronically. Some of them use them to read all the non-jurisdictional cases, those things we're required to read under the Ohio Constitution. I don't use my staff like that. I read every single case, and I am a paper reader. I cannot focus electronically. I have a very difficult time concentration-wise. For some reason, my brain just has a disconnect with electronic reading. I like to underline, I like to highlight, I like to make notes, I like to dog-ear pages so it reminds me that page is important. I lose myself in just skimming when I read electronically. So I read every single case and I log a vote. If I want more research done on that case or I have a question, I'm not really sure that the outcome was right, and I'll tell them why. Because I think if you practice law a long time, like I have, you get a gut reaction to certain things. So I was a general practitioner when I was in private practice. I was a true general practitioner. So I would do criminal cases to probate cases, domestic relations, juvenile, you name it, I kind of did it. I was the catch-all. I didn't really specialize. So some of those come through that reading, and I just remember from that practice and then my specialty work as a trial court judge. So if I have a question, I'll say, I'm a tentative grant, but this is why I'm tentative. I'm not really sure about X, Y, or Z, or please do some research. And then I submit that back to the office. I don't micromanage. The 3 staff attorneys work together to divvy up those questions. I really set them on merit briefs. So those cases that are orally argued, those are merit cases. Each staff attorney takes one, they write a bench memo. That memo is not to tell me what they think I want to hear. That bench memo is to tell me what they think the law is. Because I'm reading that same case, I'm doing my own research, and I'm coming to my own conclusion. And when they don't match, it gives me the opportunity to have the debate that I'm really going to see in the courtroom at the time. And then they actually do follow up on the batch votes. They're the ones to make sure what the 4-3 Rs, if I'm watching a case, what that is, what it comes in. I spent a lot of time on the phone, so driving up here this morning, I probably had an hour call with one of my staff attorneys about a case that we're working on. We're writing something. So I've written something over the weekend and I sent it to them late last night. We're talking about it. They had already read it. So we're talking about what I call the open issues are, the things that I'm not really certain of. And we're just going to do some more research on those areas. But some of the justices use them to write bench memos on every single one of those cases. And for me, my job's to read the questions I'm asked to hear. And if I need help on that, then I ask them. But by and large, I actually feel it's more expedient and efficient for me to do that reading first. After all, I'm the decision maker. Thank you so much. That's a great question. I've never been asked that. Yes, ma'am.
We hear more about executive orders now as time moves on at different levels of government. What kind of criteria do you use to determine if you do whether or not an executive order is appropriate, or if that issue is supposed to come out of legislative action?
That is a $1 million question. Thank you, ma'am. Really, executive power is cabined both by the United States Constitution and by the Ohio Constitution. The executive branch does not have independent functionality to create law. As you start seeing those executive orders happen, that question first becomes, did they have constitutional authority to issue the order? What is the power behind that? I'll use an example of, because I know Speaker Boehner, that in his term of speakership with President Obama, that they sued more than 90 times over an overreach of executive power. And those cases would go into the federal system. As you started looking at that, then the federal courts would have to decide whether or not he had the power to do it, and if not, strike it down and reset liberty and order. It's the overreach that the Constitution is trying to cabin, making sure that each of the three separate but co-equal branches of government operating independently are exercising only that power that is given to them under the Constitution. So for me, as a reader, you begin at the Constitution. And then if they are claiming some sort of statutory power, you then go to the statute as well. But words have meaning, and every word has a meaning. And unless that is an express authorization of power by a statute, you don't have that power. For example, I'll use the courts. In Belmont County, there was a probate judge, and they were getting ready to grant an adoption of a child or children. However, those children were subject to custody orders in West Virginia. The case originated in West Virginia. It was an ongoing concern, and there were ongoing custody orders in that case. And they were working on a reunification of a mother to these children. The probate judge went ahead and granted the adoption, despite a lack of jurisdiction. We overturned it. We said it is beyond your power or authority to exercise control or jurisdiction over those children because they are really under the jurisdiction of West Virginia. So when you start looking at powers, what are the powers that you're entitled to exercise? What is the order that is given? Unfortunately, and I'm speaking now as just a person, Sharon Kennedy, the person. Unfortunately, what I see is when all powers are seized by one party, there is often never a check on the overreach of those powers because they don't want to fight their own party. It is the failure of our system. It is something that George Washington actually cautioned against in his farewell address. Never spoken, but published in the New York Times in that day. And one was to tell all of us to be careful of how closely we align with political affiliation, because there will come a time when that affiliation is overbearing on the rights of freedom and liberty in the people. His address would have been well heeded in many an era in this country. But to me, we must elect individuals who are steadfast committed and disciplined to exercising only the power they have and not to engage in overreach. Benevolency is still a dictatorship. Yes, sir.
We hear so many times that an issue or an opinion or an action is unconstitutional. What does that mean?
So it depends on which frame of reference you're talking about. So as the general conversation happens, right? Let's just take social media for example. It's being argued that social media platforms are stripping individuals of their First Amendment right to free speech. But 2 years ago when I was here, what did I tell you? You need a government actor in order to cabin free speech or violate someone's free speech. And in a case where you have stand-in, and this is one of those legal terms we use, but it really means you are directly injured by an action taken by an individual, you have standing to sue. So the federal government comes in and shuts down her church, and she says, you are violating my First Amendment right to express religion, and you don't have the ability to do that. Because it's her church and she's being shut down, she has a personal injury, she can sue in the federal court system or even in the state system. And she also argues an Ohio violation, but she could also argue the US Constitution and still have standing in Ohio court. That then becomes the question of, is it unconstitutional? Is it a government actor? Are they prohibiting the free exercise of religion? And if it is, we declare it unconstitutional, which means whatever order is or whatever issue was put in place to stop the church from operating, that gets decided. So it's unconstitutional when the court declares it so. As for the conversation, all of us have an opinion as to whether or not we believe something violates our personal fundamental rights of freedom. But that's a personal opinion until a court declares it so. But we will have raging debate in this country until it reaches the court with an individual who has standing. I'm well past my time. May God bless all of you, and thank you for being Rotarians.
Thank you for taking time out of your schedule to visit with us today. We appreciate you taking us through some of the processes at the Ohio Supreme Court. In recognition of your time with us today, we have our Rotary wheel and the four-way test on the back, and these are made locally by the Village Network.
Perfect.
Thank you.
Thank you so much. Thank you.
Quick reminder, next week, our speaker will be John Detro with the topic of a life in radio. And John will be joining us virtually, so we're going to have a unique situation next week. Hopefully everything will go well with that. So with that, I will adjourn. Have a good week, Rotarians.